Criminal Procedure and Civil Rights. The Fourth Amendment says, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized." In this video lecture, we will only deal with the first part of the Fourth Amendment, the one that prohibits unreasonable searches and seizures, and we will not review the warrant clause that explains that warrants can be issued only upon probable cause. The first case we consider is Mapp versus Ohio. It was decided in 1961. Dory Mapp's house was searched without a warrant, and she was convicted for the possession of obscene materials. She appealed her conviction on two grounds. First, she claimed that her freedom of speech was violated, and the obscene materials she held should not have been introduced into evidence in a criminal trial because they are protected by the First Amendment. Her second defense was that because her house was searched without a warrant, any evidence seized should be dismissed. Now, it just so happened that the Supreme Court of the United States decided not to address the First Amendment issue at all, and it simply ruled that all evidence obtained by searches and seizures in violation of the Constitution is, by the Fourth Amendment, inadmissible in a state court. This case was important because in this case the exclusionary rule was incorporated. Prior to Mapp versus Ohio, evidence that was illegally obtained was not admissible in a federal court. However, it was admissible in a state court unless the state's own law prohibited that. So prior to Mapp, there was no constitutional protection under the Constitution of the United States of illegally seized evidence to be used against you. Mapp has changed all this. Just as an interesting fact, the police were searching Mapp's home because they were looking for people who firebombed Don King's house. You might know about Don King. He's a famous boxing promoter. And when he was a very young man in Ohio in the late 1950s, he was involved in illegal gambling. He had a quarrel with some rather angry gentlemen who decided to firebomb his house, and the police believed that those gentlemen might have been hiding out in Dory Mapp's house. They were not. They didn't find them there. They did not even find any evidence of illegal gambling. They thought they might find that too, but they did find in a locked trunk some obscene comics, and they were able to use those to get a conviction in an Ohio state court. But the Supreme Court obviously overturned on appeal and incorporated the exclusionary rule. What does this mean to you as a citizen? It means that if the police seizes evidence, any evidence, illegally, that evidence cannot be introduced against you in court. Our next case is Terry versus Ohio, decided in 1968. The events that led up to this case actually began on Halloween of 1963. Now, Halloween 1963 is also featured in the fictional universe of Halloween movies, whereby we learn from the original Halloween movie that Michael Myers kills his older sister on Halloween night of 1963. However, Terry versus Ohio was not a fictional case at all. I mean, the events really happened. They happened on Halloween, and no one was stabbing anyone. What simply happened was that an undercover police officer named Martin McFadden observed two men pacing up and down the street, and more specifically Euclid Avenue, in Cleveland, Ohio. And every time they passed by a store, they looked into the store's window. And in total, each of them made 5 to 6 trips. So since they walked by the store separately, the total number of trips was approximately a dozen trips. And then police officer McFadden also observed Terry and his companion named Chilton talking to a third guy named Cutts. Then Cutts left, and soon thereafter, Terry and Chilton followed a few blocks away, followed Cutts. They were all talking together a few blocks away from where Terry and Chilton had been pacing in front of the store, and police officer McFadden followed all this. He followed the three men. He approached them, identified himself as a police officer, and asked them their names. And when Terry unintelligibly mumbled his name, the police officer spun him around and frisked his clothes, his coat, and he felt some hard object that he believed to be a gun, but could not remove it immediately. So in order to control the situation better, Officer McFadden ordered the three men to go inside a nearby store, and he forced Terry to remove his overcoat and was able to extract a gun from that coat. And the police officer also searched Chilton and found a gun on Chilton. Terry and Chilton were convicted for possession of concealed firearm and sentenced to prison. There was no weapon found on Cutts when he was patted down, so only Terry and Chilton were convicted. Terry and Chilton appealed their convictions on the grounds that police officer had no probable cause to search them. The Supreme Court of the United States agreed to take the case, and by an 8-1 decision, the court found that the search and frisk conducted by Officer McFadden was in fact constitutional, because the court said that the police officer acted on more than just a hunch. The officer has in fact acted on reasonable suspicion, and this reasonable suspicion was supported by specific and articulable facts, and the scope of the search was limited. It was reasonably related to the nature of the suspicion. Therefore, the weapons found as a result of the search were admissible in court as evidence, and Terry's and Chilton's conviction was proper. So this case is significant because it established an intermediate standard of interaction between the police and the public. What do I mean by this? I mean that today we can understand all interaction between the police and the public as based on three different levels. First, voluntary contact. Second, the intermediate level is contact based on reasonable suspicion. And third, based on probable cause that crime has been committed or is about to be committed or is being committed. Voluntary contact can be initiated by a police officer on the street for any reason. Maybe a police officer has a hunch that something is wrong. The police officer does not need to have probable cause, does not need to have reasonable suspicion. And in fact, the courts have ruled that a state law may require that a police officer asks a person for an identification. So in fact, approaching a person and trying to talk to a person is not constitutionally forbidden to a police officer. So that's voluntary contact. On the other side of the spectrum is probable cause. If a police officer has probable cause, he or she can in fact arrest you, probable cause that crime has been committed. Whereas if the contact is entirely voluntary contact, then the citizen can say, well, I would not like to talk to you, so can I go? So voluntary contact can be cut off by a citizen. If the contact is based on probable cause, it cannot be cut off by a citizen because a citizen can be arrested. But if a police officer has less than a probable cause, but more than a hunch, if he or she has reasonable suspicion that a crime has been committed, is being committed, or is about to be committed, then police officer can detain, meaning to stop, and frisk, meaning to search the outer clothing of a person for evidence that is related to the nature of the suspicion. So the court has ruled in Terry that if suspicion is that robbery might take place, what do people use during a robbery? They use weapons. So for police officers' safety, if such a stop is made, if a Terry stop is made, a police officer can search, can frisk a person for weapons, limited search or frisk. And of course, if contraband is found, then this encounter escalates. It no longer is based on reasonable suspicion. Now it's based on probable cause, and probable cause justifies arrest and unlimited search. So this was an important case. Note the decision was 8-1. Only one justice, Justice Douglas, dissented in this case. This is pretty remarkable because in the 1960s, we had a very liberal court, sympathetic to defendants and suspicious of police and prosecutors. But even on this liberal court, probably the most liberal court ever in American history, only one justice was willing to limit the power of the police to conduct limited detention and limited search based on reasonable suspicion. Only one, just one. Michigan Department of State Police versus Sitz was the case that tried to prevent the police from conducting sobriety checkpoints. You already know how this case turned out, unless you live under a rock somewhere. You know that sobriety checkpoints in the United States take place all the time. In 1986, the Michigan State Police Department created a sobriety checkpoint program aimed at reducing drunk driving within a state. Let me just clarify what state police means. Some states call their local enforcement officers state police, like Michigan. Other states, the vast majority of states, in fact, call them highway patrol. So if you live in Nevada, it's going to be Nevada Highway Patrol, California Highway Patrol. So in Michigan, it was state police. They had the sobriety checkpoint program, and this program included guidelines governing the location of these checkpoints. And there was publicity given that operations will take place. But even before the first sobriety checkpoint was implemented, Rick Sitz filed a petition, an injunction with the court asking for injunctive relief. An injunctive relief is when you ask a court to stop the government or stop someone from doing something because it's going to adversely affect you. And he said, I'm a licensed driver in Michigan. I drive here, and I don't want my rights to be violated. So I'm filing for injunctive relief. I'm asking the court to prevent the police from even erecting any checkpoints because I don't want to have my constitutional rights violated. It just so happened that the Supreme Court ruled in favor of Department of State Police. Why? Because the court said that sobriety checkpoints save lives and do not violate the Fourth Amendment because the government has a compelling purpose in saving lives, and the checkpoints are sufficiently narrowly tailored as a means to help save lives. The decision was 6-3. The Fifth Amendment. This is a lone amendment. The part that concerns us here is, nor shall be compelled in any criminal case to be a witness against himself. This is the part of the Fifth Amendment that protects people against self-incrimination. And the classic case is Miranda versus Arizona. Ernesto Miranda was a young man who was arrested and taken to a police station and identified by the victim, and he was taken to an interrogation room. After a number of hours of interrogation, he signed a standard disclaimer, a waiver of his rights. He said that I have full knowledge of my legal rights, understanding that any statement I make may be used against me, and he signed that waiver, and he signed a confession, admitting that he kidnapped and raped a woman. Now, he was tried, and on the basis of his confession, he was convicted of kidnapping and rape and received a 20-year sentence. On appeal, Miranda argued that his conviction should be overturned because his confession should not be admitted in court because he was not informed of his rights prior to interrogation in police custody, but only after interrogation. And so the argument was the burden on proof is on the police to properly inform a person in their custody of the person's legal rights before they begin interrogation. And the Supreme Court agreed. I will point out right away that the decision was very narrow, 5-4. And in this case, the Supreme Court, in fact, rewrote the police manual, stating that protection against self-incrimination must include the right of all people in police custody to be informed of specific rights. That is, the right to remain silent, the right to an attorney, the disclaimer that anything they say can and will be used against them in the court of law. And if the police doesn't inform them of their rights, then any statements made could be inadmissible in a court of law. It's interesting that Justice Byron Wright, who filed a dissent in this case, just about became apoplectic. He said that this decision in Miranda versus Arizona is going to unleash hordes of criminals onto America's streets, because now a lot of people will not be convicted due to a police mistake, due to some technicality when the police forgets to read them their rights or reads them their rights incorrectly. Well, it's interesting why this hasn't actually happened. Why was Byron Wright incorrect? Why hasn't the Miranda decision unleashed the hordes of hardened criminals onto America's streets? The answer is very simple, and we understand it when we look at what actually happened to Ernesto Miranda. His conviction was indeed overturned, but then he was tried again. This time, not based on that conviction, but rather based on the testimony of the victim. And he was convicted and sentenced to prison. I want to point out that this is not considered double jeopardy. It's never double jeopardy if your conviction is overturned on a technicality or if there is a hung jury. You can be tried again. It's only double jeopardy if you're found not guilty and then they try you again. That's double jeopardy, but that's not what happened here. Here you had a conviction overturned on a technicality. In a case like that, you can be tried again. And this is exactly what happens to virtually everyone whose conviction is overturned on a technicality. They're tried again, and most of the time they're convicted. Ernesto Miranda ended up in prison. But apparently what happened back then is Arizona had a fairly liberal parole program. I don't think that in today's world in Arizona, Ernesto Miranda would have been out of prison as fast as he was back then. He got out of prison. He got himself into an argument over a card game in some bar in Phoenix, Arizona, and he was stabbed to death. His assailants escaped, but they were quickly apprehended, and when they were arrested, the police read them their Miranda rights. Today, Miranda rights are, of course, a part of the culture because on every television cop show, and there's like 100 of them, I think, you see the police reading suspects they arrest their rights. I will point out that it's important to keep in mind the police does not have to read you your rights at the time they arrest you. They have to read you your rights before they interrogate you. Is this an important distinction? Yes, it is. In the vast majority of cases, the police will read you your rights at the time they arrest you so that there is no doubt that any questions they ask subsequently, all the answers count, all the answers that you give count and cannot be dismissed, and so that they would not forget to read you your rights. But technically, rights do not have to be read at the time of arrest, only prior to interrogation. The Sixth Amendment the case that we will consider here is Gideon versus Wright, and in this video lecture I will only consider the protection to have an attorney, what it means to have an attorney. The Sixth Amendment is a law amendment and has a series of protections, but I will only consider the right to an attorney. Clarence Gideon was an indigent defendant in this case, Gideon versus Wright. He was charged with burglarizing a pool hall, and he was sentenced to 5 years in state prison. At his trial, he asked the judge for an attorney because he couldn't afford one, and the judge said, sorry, we can't give you one because we only give an attorney if you are charged with a capital crime. No, well, a capital crime is a crime for which you can get the death penalty. And this is because the case Betts versus Brady in 1942 said that in cases where death penalty is a potential punishment, states must give an attorney. And also states cannot deny a person an attorney if a person hired one for himself or herself. The state cannot say, okay, this is a criminal case against you and you hired an attorney, but we won't allow to have you one. That can happen. But before Gideon versus Wainwright, the state didn't have to give you an attorney. It couldn't stop you from hiring one, and it had to give you one only in capital cases, but not in any other cases. So Gideon was convicted without having the benefit of an attorney representing him. And so you can imagine that the legal arsenal on the side of the prosecution and on the side of an indigent defendant who knows nothing about the law is very unbalanced. The prosecution is very experienced in criminal law, and an indigent defendant without a lawyer is the opposite, is inexperienced. So Gideon started studying law while he was in prison, and he wrote a handwritten petition to the Supreme Court asking the court to review his case, which was in fact reviewed. The Supreme Court overturned Betts versus Brady and said that in fact Gideon was incorrectly denied an attorney. The state must provide an attorney in serious criminal cases. So as a result of this unanimous Supreme Court decision, everyone who is tried in a felony case for a felony charge has to be given an attorney. 9 years later, in Archer Sinner versus Hamlin, the Supreme Court extended the right to an attorney to all cases in which prison or jail was a potential punishment. Remember, Gideon was a felony case, but what about less serious cases or misdemeanor cases? It was only Archer Sinner versus Hamlin that established the right to an attorney in misdemeanor cases if punishment could include prison. Without such a right, said the Supreme Court, it would be easy for people to fall victim to assembly line justice, where judges just dispense with cases in a very cavalier, very fast way, just to move the person through the system, but the result would be that a person would end up in prison, which is a harsh punishment, and people should have a right to an attorney if they can end up in prison.